Now, I think I've said enough on that subject to say we'll move on to that debate a little further in another session, but move on to another part of this session, and that is, what about, though, if they're dangerous to other people? I've been talking so far about danger to themselves. They don't have the wherewithal, according to the opposition, my point of view. They don't have the ability to give consent to us giving help to them, but nobody's saying they're dangerous to other people. But let's move on to danger to others. In the 60s, when society was changing some of its ideas, and we've now fallen away from it again, people began to say, you know what? We shouldn't be able to force treatment on people unless they're a danger to others, not because they're just, or not because they just need treatment. It should only be if they're either a danger to others or danger to themselves, immediate danger to themselves. Well, the evidence is very, very clear. That is not a good policy, even though psychiatrists continue to defend it as a way to justify forced treatment, because there's plenty of evidence that come in that psychiatrists don't know how to tell who's dangerous. When you ask somebody to predict something, which is an unlikely thing, of all the people whose behavior causes other people to get worried, the vast majority of do not do anything that people are thinking they might do. The evidence of that is very clear. So you're asking a psychiatrist to predict something which is an unlikely event. And the statisticians will tell you that when you try to predict based on the examination of an individual person, they're carrying out an act which is known to be an unlikely act, you will be right very, very infrequently and wrong very, very frequently. So you immediately run up against the problem that the price you will pay as a society for trying to stop unwanted behavior that is a danger to other people, you will infringe on the civil rights of thousands of people for every one person that might have turned out to do something wrong. The next argument against it is that you'd have to have some good evidence that people who have mental problems, the kind that psychiatrists are asked to deal with, have a higher likelihood of doing something than other people. But even the psychiatric community acknowledges that the incidence of dangerous, violent behavior is lower in people with a history of mental disorder than it is with the population in general. So you've got a population which is off target, being supposedly sent to a population of experts who themselves have admitted they don't have that kind of expertise. And let me just finish up this session by illustrating the inconsistency of psychiatry's admission that they don't know how to do it. Because while psychiatry does say we don't know how to predict dangerousness in a long term, they still want to claim that they can select those people who we should be able to treat against their will in the short term. In other words, they still try to defend involuntary treatment of patients in mental hospitals for days, weeks, or even months. But they don't want to get in, say, locking people up for 30 or 40 years based on a psychiatric prediction of dangerousness. So let me illustrate how the hypocrisy can run through society. And again, underline the message that don't be just pointing the finger at the psychiatrists. We're all in this together in terms of the problem and the solutions. And I'm talking about the practice of asking for psychiatrists to give opinions in death penalty hearings. Now that would be a legal situation where a person has been convicted already of a crime that could carry the death penalty. That would be typically murder, but it could be some other crimes as well that could carry the death penalty. Now, in the states, and the one that got the most attention was the state of Texas, because back in the 60s and 70s and 80s, they were calling one doctor over and over again. But he wasn't the only one doing it, but he did it the most, and was consistently giving opinions that if you don't execute this person, he will kill again. And there was another trial after the person had been found guilty, and maybe there had been an insanity defense and that had been rejected. They were now guilty of the crime. The law required there to be a next trial on the issue of whether or not they would be so dangerous that anything less than the death penalty would be too dangerous to society. And the doctor who was doing this developed a pretty bad reputation among psychiatrists. Just for the sake of showing that this is not a matter of personal thing here, I'm not even going to mention his name. I don't even believe he's alive anymore, but even if he were, it doesn't matter. This was a particular psychiatrist. And the American Psychiatric Association didn't like the fact that psychiatrists were asked to give opinions in such hearings. It was giving them a bad name. They were already getting a bad name in a lot of other ways. They were being criticized for changing homosexuality and taking it out of the diagnostic manual by some people. They were saying, you know, how can you change your diagnostic labels based on a vote in a committee or in a meeting? That doesn't sound like science to me. But there was enough pressure, and of course, I'm in total agreement. The homosexual community was lobbying, and eventually the psychiatrist said, you know what, it's not a mental disorder unless you, the homosexual, it bothers you, then it is a mental disorder. And it was kind of a subject of, you know, derision amongst many people. What kind of science is that? Psychiatry was anxious not to be put in positions where they were made to look bad. And there was a lot of data showing psychiatrists' attempt to predict dangerousness was no good. You could flip a coin and do better. And so in the issue of psychiatrists predicting dangerousness, in death penalty hearings, the American Psychiatric Association actually filed a brief when the case got all the way to the Supreme Court, where you had the state saying, we need psychiatric testimony to back up, to get decisions about the death penalty. And then the other courts ruling, no, that doesn't work out. We don't think they should do that. So it goes to the higher court, the next court, and all the way to the Supreme Court. They filed a brief, what's called a friend of the court brief. And the American Psychiatric Association, as the dominant organization, said, with many, many leading psychiatrists leading the way, saying, you shouldn't ask us to predict this dangerousness because we don't have special skills in telling who's dangerous. And it's the Supreme Court's response, as I'm wanting to bring up here, is to illustrate how, to the highest echelon, in this case of the judicial branch, we want to rely on our psychiatrists. The Supreme Court, in essence, said, and I'm boiling it down, obviously I haven't memorized the language of the court, but I did submit a letter to the California Supreme Court on some of the very same issues, so I was quite immersed in that. The Supreme Court said to the amicus brief of the psychiatrists, you haven't demonstrated that you're worse than anybody else in making these predictions. So we don't see any harm in these psychiatric opinions. Therefore, they refused to set a precedent saying that psychiatric testimony would not be allowed on a question which the very people who were supposed to do it said, we don't know how to do it. Instead, what the Supreme Court said was, if people feel they want to use it and present it as expert testimony, go right ahead. You're free to do that. And let me just tell you, finally, to finish up, why that's such a violation of the law by the Supreme Court. Because the law says that experts are only allowed to do something that is within a narrow view. Experts are allowed to give opinions in court. Expert witnesses give opinions. Lay witnesses are not allowed to give opinions. They only testify about what they've seen or heard, what they have evidence for, to help lay people make decisions. And then experts, if they have knowledge in areas that are beyond what lay people have experience with, they're allowed to give opinions, but those opinions are weighed by the judge or the jury. The opinions of the experts do not automatically get given weight by a court. Only the people who decide the case decide, I don't like that testimony, I don't believe it, it doesn't convince me. Oh yes, I am convinced by this expert. That's the way it's supposed to work. But the Supreme Court was saying, the very people that we're turning to and that say we don't know how to do it, go ahead and use them anyway. So what does that tell us about us as a society? That as a society, we are still immature. We are still not yet ready to face the truth about what psychiatry is. We hurt ourselves by doing that. We hurt our desire to be helpful to people and to decide when our money, our finances, our political will goes in what direction. All questions are way beyond in my expertise, but we can enhance the possibility of us moving in good directions if we begin by getting rid of our false prophets, by putting psychiatry in the position that it belongs, which is one of the helping professions that needs to be regulated and needs to be made up of educated professionals, but is not in a position of being a high priest or being a medical doctor or using alleged medical skills that it doesn't have, and put in a position where it can use some medical skills that it has. And in one of the sessions we will go into what medical skills psychiatrists do have. And there are some of those, but it's not in diagnosing mental disorder that is not known to be a medical disorder. And it certainly is not in the area of helping us with the problem of either danger to self or danger to others. See you next time, and thanks for being here.